Good morning, and thank you everybody for joining Thompson Hine's weekly coffee chat series. My name is Marc Miner, and I'm Senior Counsel in Thompson Hine's Investment Management Practice Group. Joining me today is Bill Reilly, Associate Director at Oyster Consulting. Receiving an inquiry from a regulator can be jarring, and how you respond in the days and hours immediately after can quite literally save the day or doom the outcome. Today, we will explain what regulators are thinking during the investigation, as much as one can tell that, how to assess risks of cooperating or being combative, and which negotiation or settlement strategies have the best return on investment. This chat will help you plan in advance for all the things that need to be considered. Resolving a matter informally or formally. Is the matter reportable or not reportable? Admitting or neither admitting or denying, individual liability, restitution, disgorgement, fines, penalties, and many more. If you have questions or comments during today's program, we note that there is a chat and question, a Q&A feature in your control panel on the right. We'll try to address questions as we get them in turn, and we're going to save some time at the end for additional questions. If for any reason we don't get to them during this program, we'll certainly follow up with you today. So with that, let's get started. Good morning, Bill.
Good morning, Marc.
Look, I'm so excited that we could talk about this topic. Bill and I have known each other for many years and have traversed this area for a long time. And so when we were speaking about mock exams or preparing for regulatory engagement, it seemed like a lot of things were kind of spilling over into today's topic. And so I'm excited to be able to cover what you have to do. So first things first, let's drill down a little bit on what happens when you're likely to be found in violation of something, or worse, charged with an action. Whether it's the SEC or FINRA or a state securities regulator, all who have a bit of a different approach to some degree, how do you determine what the regulatory risk is for the big picture as you plan how to respond?
Oh, thank you, Marc. Yeah, I think one of the things that's really important, and you mentioned it, is the fact that, look, both of us were, to our current jobs, were consultants, and prior to that, we were both regulators. I used to run the state of Florida examination program and so forth. And I think the thing that's important is you mentioned it, risk, okay? One of the things looking at, working with a client is the fact that what we want to do is we want to make sure that we're able to portray to a regulator, whether it be the SEC or FINRA or a state, those are generally the three that we're going to be involved in, is the fact of working with the client that we're working with. We have somehow been able to mitigate the risk to the regulatory agency. And I think it's also important, like I said, when you're dealing with, sometimes you're dealing with FINRA or you're dealing with the SEC, we're talking one regulatory body, or I'm sorry, the SEC and FINRA being, separate. But at the same time, when you're dealing with a state or states, you could be dealing with one state, 3 states, 5 states, or in some situations, I've been involved in task forces as a former regulator where, trying to look at trying to bring these matters to some sort of resolution. So you're right, depending upon who the regulator is, may provide a different means or platform for looking to bring some sort of resolution to that case.
Right. I always am thinking first about who's calling or knocking on the door. And what stage are we? So you certainly want someone who is competent and familiar with that particular regulator, or even that division within the regulator. Like you said, you spent many, many years. I consider you an expert in all things examination. And there are people who specialize in those. And so sometimes if I'm calling or if I'm receiving a call from a client, they kind of lump all those together. But whether you are engaging with an examination team, right, or an inquiry from enforcement, could be very important to figuring out who it is that you're going to deploy. And you need to understand the rules that apply to that particular regulator and what they're focused on. FINRA, I spent years in enforcement at FINRA, would famously say that their priority is always first seeking restitution for customers, and then obviously fixing the harm. But famously, just in June, FINRA took an action against Robinhood, and everybody knows the Robinhood story, where they gave the largest penalty ever, $57 million, and it was $12 million or so worth of harm. And so it's useful to know what that regulator usually finds important and what their historical practices are.
Yeah, I would think also, Mark, just to kind of look at that, you need to understand what the protocols are. You need to understand what how you approach a regulator. You need to look at the various personalities that are involved. There are some regulators. There may be some at the state level, others at whether it's at the SRO, at FINRA, or the SEC. Understanding personalities, understanding different approaches for contacting these regulators. And I think both you and I have that kind of process down by the fact that many times I sat on the opposite side of the table when people came in to talk about those processes. So meeting these people, understanding processes, determining, what, like you said, what is FINRA looking for? What is the SEC looking for? What is the state looking for? And how do you try to get to that place where you can come to some sort of mutual resolution of the issues at hand?
Right. And I think you, like I, are being contacted by clients at various stages of these inquiries. And so it's also important to figure out when you may be in the process of some review or conversation with a regulator where you need to bring in, obviously there are various reasons why you might want or need to bring in someone, whether that's a consultant or a lawyer, where the depth of the issue kind of goes beyond the routine review. There's also lots of other reasons for protection issues that you might not want to be the frontline person who is communicating with the regulator. And so, trying to figure out where it is in its review. Is this some deficiency that may have been presented and you're in the middle of an examination? I always like to figure out at what stage I'm becoming involved, because there are important considerations that need to be reached there. Hopefully it's before there's some final determination. But certainly if there's been an expressed decision or intention by the regulator, whether it's through something formal like a Wells notice that the SEC will issue when it intends to do something, or an examination, a finding, having somebody who really knows and understands the personality and character of that particular regulator could be a very important. Sometimes the activity is involving issues or allegations of fraud. And anytime there's an allegation of fraud, there's an opportunity for someone to suggest that that's not just some violation of some civil rule or some procedure, but there could be criminal consequences. And so those are always important. From an institution standpoint, I would also add that one of the first things that I try to assess is whether there is any focus on an individual, whether that's an executive and they might have some exposure, or a committee. Very often a regulator will look to see whether or not an audit committee or some other group knew something, or knew or should have known, or acted pursuant to or in the absence of policies and procedures. Most importantly, I'm looking to understand what are the facts show, or could equally important, what does the regulator believe has occurred? Sometimes there's a huge gap between those things, and we can be useful in educating the investigator or the regulator about why they might be perceiving something in a way without fully understanding the client's circumstance. Do you have any thoughts on helping to shape that?
Yeah, let me just mention, I mean, there are some times when I may get a phone call, an email, some sort of inquiry. Hey, a certain regulator has informed me that they're going to be, well, used to be prior to the pandemic that they're going to be in my office, in 2 weeks from Monday. Okay, now it's a fact that a lot of these reviews and investigations are done, virtually. So it's a situation where they're saying, and I want to make sure, I need to make sure that I'm prepared. I need to understand what's going to occur. I've never had this happen before. What can you tell me? So what I will do is I'll sit down and work with them and kind of see what kind of records. Usually there's some sort of letter that goes out requesting records be provided ahead of time. I will work with clients to make sure that they provide the records that are requested. Look, and it's very clear, one thing that you really don't want to do, and I don't think regulators want it either, they don't want everything, including the kitchen sink. If they ask for records, give them the records that they're asking for. We can look at those, we can review those, we can see whether or not there's any issues, but we do have to provide those records. But as you said, Marc, there's some sort of explanation, there's some sort of conversation that will take place early on in the interview process where we can discuss, why a record may be maintained this way or not maintained that way. And look, I will also tell you many times that when regulators, come through the door, and I was very careful to explain this to staff. I used to say, don't go out and say, I want a certain kind of record or a certain type of report. Describe what the report is, and then, and have an understanding. Some people will say, I want your purchase and sales blotter. And, someone may say, well, that's my form 7248. If you put it out that way, then I would understand it. So it's imperative for firms to have a good understanding. What is being requested? What's the obligation to provide those records? Again, when you provide records are reviewed. And again, regulators do have a lot of examinations, have a lot of things out there, and you want to make sure that you provide documents, but make sure that it's responsive to those requests.
No, I think that's an excellent point. It kind of leads to my next section. If you want to understand the scope of the investigation, most regulators will actually appreciate an iterative process where if they've sent out a request for information, a subpoena, or a set of examination requests, that if you believe that they are barking up the wrong tree, or that they probably mean X when they're asking for Y, no one really wants to spin their wheels and have people spend useless hours looking over things that are immaterial or irrelevant, or getting a truckload of information that's not directly on point. And it's essential for you at the firm or in your compliance department or as a professional to help assess this question of what is the scope and what is the risk. And that includes how widespread is this alleged activity? How long has it been going on? And was it done knowingly? What's the financial impact? What's the number of customers? This record fine that I just described was really a function, according to the statements of FINRA, was because the activity was so widespread. And so that in itself is its own risk. And so assessments of risk are kind of all those things together. But at the time, let's talk about the right person for the job. At the time that someone needs to get back to the regulator and ask questions about whether or not this is the appropriate scope, who do you recommend is having those conversations?
Well, look, I can tell you, and I'm now in my ninth year as being a consultant for Oyster. Um, I can tell you that I may have a conversation with a regulator, to kind of get an explanation what their concern, what their issue is, and many times, um, they will explain, "Hey, I've got some concerns about, we've got 12 complaints against this firm, or we've got a certain other activity." So I think it's incumbent, whether it's a consultant or like in the situation of you, Mark, an attorney. I think it's important to make sure, like you said, we have a good understanding. What are the issues? What are the concerns? So that a person like you or me can start to look at it and say, okay, let's see how serious this concern is. Is it something that looks like it's maybe going to head to something that would maybe be resolved informally? Or are we looking at something here that's going to head more to a formal type of resolution? Now, I'm a consultant. I am not an attorney. There are many times what will happen is when I get a call from a company and I will work with them up to a certain point in time. But when I see a situation where I'm looking at this as maybe being resolved through something other than an informal matter, what I mean by an informal matter is either being closed or through some sort of admonishment or cautionary letter, there comes a certain point in time, well, I will talk to the firm that, hey, this is getting to the point where we might want to consider getting someone who's an attorney involved, in that process. There are also other times when people will contact me after an administrative complaint has been filed. Okay, and that's a whole different ballgame there. They'll talk to me, they'll provide me information. And when you get to the point where there's an administrative complaint that's been filed, we're talking about being involved in a legal matter. And if the firm does not already have counsel, I will suggest to them at that point in time that I'll be glad to work with them. I'll work with counsel. But since it's now moved from a kind of an informal to a formal type of situation, we need to have counsel involved. So I come across that. So a lot of it has to do with timing. Are we notified prior to a formal action being taken? Are we notified after it? That's going to drive how representation, how the players involved, and the type of players that need to be involved in the process.
No, I think that's an excellent point. I was involved in a matter last year where, to your example, the majority of states were making inquiries of a particular client, and the best relationship we ever could have engaged in for that particular client was to immediately recognizing that there were significant compliance and regulatory changes that we wanted to be able to report. They have already undertaken by the time we sat down, was to insert an experienced and competent a consulting firm that knew the area and how to get them from A to B in terms of compliance, and a really buttoned up ship. And I think it made all the difference. And so we do very much the same thing in our assessments.
Yeah, let me follow up on that, Mark. I think it's very important. And one of the things when I'm dealing with a firm, whether it's with or without an attorney, one of the things that I'm going to suggest, and we'll talk about this in a minute about aggravating and mitigating and principal considerations for resolving cases, but I'm going to recommend that if there's an issue, that we need to fix it. And there needs to be what we would call an independent third party. And many times I've actually met that criteria, gone in, reviewed the activity in question. Okay, now again, this is before we're getting to the point of a formal type of action, and while we're maybe discussing, with a regulator. Okay, but what we'll do is we'll go in, take a look at the activity. It could be one area or multiple areas. We'll go in, we'll look at it, we'll find any problems. We will make recommendations for updating to processes, written supervisory procedures, maybe even do some testing. Okay, because what we want to be able to do, whether it's a consultant or Mark, you're involved as an attorney, we want to be able to say, hey, we had an issue. We think we've corrected it, we've tested it, and here's the results. Because one of the things we're looking at when we get before that regulator, whether it's informal or formal, is, we're looking to mitigate, certain activity. And again, to show the regulator that the risk that may have been in place prior to this independent third-party review has been addressed, tested, and we think the firm is going to be able to, be compliant, not only this area, but other areas moving forward. And I think that's an important representation to make to a regulator.
Well, that's an excellent point, and it can be certainly a strategic advantage to you to certainly know the entire universe of what could come up at the time that you're sitting down at the negotiating table. But let me drill down that a little further. Sometimes you are finding things during the course of your internal investigation that the regulator is going to find out about. It's widely debated about what the utility is for these special situations like self-reporting, or whether you are really getting credit for cooperation when you do self-report and help the regulator pull all the pieces together. What's your thoughts based on your experience on that?
Yeah, very good point, Mark. Look, one of the things FINRA has, disciplinary guidelines and, basically, principal considerations for resolving cases, okay? NASA also has a similar document that they utilize. And as a result of the 2008 market meltdown, the Florida legislature required the state of Florida to put together basically a penalty matrix, okay, which would put together a matrix of range of penalties. But also one other important part of that was putting together aggravating and mitigating circumstances that would be utilized by regulator to determine, whether or not, what potential terms. Number one, do we want to settle with this company? And if the regulator wanted to settle, what would those terms be? And I was involved in that process pretty immensely. So again, one of the things that we're looking to do, whether it be a consultant or an attorney or a team of both of us, okay, we are looking to mitigate as many of the circumstances as we possibly can. And one of the things that I discuss with a lot of people is, for example, one of those mitigating or aggravating circumstances is, number one, it asks, were seniors involved and were they affected? So if the answer is yes, and there were losses, that's an aggravating factor. If seniors are not involved, then you go in and say, no, there are no seniors involved, and that's a mitigating factor. So any one of these factors that are either, like I said, with FINRA, NASA, or in my situation when I was with the state of Florida and I administered those provisions, we want to make sure that that those, you want to look at both aggravating and mitigating. And again, any one of these, I think Florida has like 25 or 26 of these aggravating and mitigating. Any one of these, depending upon their circumstance, in one circumstance they could be aggravating, in another circumstance they could be mitigating. So those are type things that attorneys and consultants like myself look to put forward when we're doing presentations and dealing with regulators. And I know, Mark, you've had a lot of experience in that on both sides of the table.
No, absolutely. There are a lot of things, and unfortunately, a lot of them are moving parts, right? All at the same time.
Yeah.
But we're clearly, if you're down to the aggravating and mitigating circumstances that you would consider in assessing risk, are definitely on the table. It sounds like if we are, let's say we are now beyond the position where we've been unable to shut it down. There is some activity that clearly the regulator is going to contemplate taking some action on. There are lots of things to keep in mind. We talked about them in the opening. One is helping to shape what a fair and reasonable resolution is. I should add here that I will often have a practical consideration, depending on the size of the firm and the resources that they have, about how far that they're going to push back versus the consequence of the recommended resolution. We are always prepared to and willing to fight as zealously as we can for our clients. That very often takes time away from the resources and the business that the institution is trying to do. And so sometimes we will simply assess at that point what we believe the likelihood of prevailing would be and the cost associated with doing something where both parties can control the results, where I find most no one is happy in that instance, but you can control the result. I want to leave just a moment or two for any questions, but I thought it would be important to note that among the things that you may consider in a resolution, we talked about restitution and some regulators seeking restitution. Issues of restitution and disgorgement have been tweaked and redefined by the United States decision in Liu, L-I-U. And so if you have not read that decision, I would encourage you to read it or contact your compliance expert so they can kind of walk you through how to measure the extent of harm under that decision, because it will be important as you sit down at the table. And then there are fines and penalties, and whether there's individual responsibility or liability. There are some institutions that have a mandate to always consider whether or not there's an individual to charge. And in the past 10 years, there's been a particular focus on chief compliance officers or compliance units, looking at whether or not there's an individual who knew or should have known, and whether or not there should be personal liability. I should also mention finally that the SEC has a personal policy on the value that it gives to cooperation. Some on the market say it's never as of much value as they hoped that it would be when they're finally delivered the ultimatum. So I don't know if you had any final thoughts before we conclude.
Yes, one of the things I'd like to mention that I look at people like myself and Marc as being people, a reputation maintenance type of individual or reputation repair, okay? When I was a regulator, many people would sit across the table from me and say, Mr. Reilly, all I have or all the firm has is their reputation, okay? And if you do certain things, that reputation is going to be tarnished. We're going to have some disciplinary actions out there on our CRD record and I look at that right now, that I look at it to say that, reputations can be maintained, reputations can be repaired, okay? There's always a situation like that. But I think it's important, and one of the things that Marc and I will do is always work to show you how that reputation can be maintained or repaired. And I think that's important. We know what regulators are looking for. We know what regulations are. We have a good understanding how to fix those areas. And that's one of the reasons why, again, it's always good to look at a consultant and or attorney when you get into these matters, because these are things that we have at our forefront.
Well, excellent words to conclude on. Bill, I thank you so much for adding your expertise to this conversation. I could talk another hour on the same topic, and maybe we'll have to do another one on the Jedi mind tricks that are played at the negotiation table. These aren't the droids you're looking for. But look, that concludes our chat for today. For those listening in, our next coffee chat will be Wednesday, July 21st, and my colleague, Mike Weibel, will be joined by Nobi Powell of Asset Management Insurance to discuss mutual fund insurance coverage. So if you've missed any past coffee chats, we encourage you to visit our library of recordings, which is available at Thompson Hine's YouTube channel. So I want to thank everybody for listening in today. And certainly, Bill, again, thank you for your insight. When this webinar ends, you will be prompted to fill out a survey. We hope you do so, and have a great day. Thanks for joining us at Coffee Chat.